This program is brought to you by Emory University.
Hi, I'm Jennifer Murphy-Romig, a legal writing professor at Emory Law School and founder of the blog Listen Like a Lawyer. I'm happy to have Gregory Parent with me today. He's a mediator at Miles Mediation in Atlanta and is here to share some thoughts on effective listening. Greg, thanks for being here.
Thank you for having me.
Let me ask a broad question to start with.
All right.
What does effective listening mean to you?
Effective listening depends on the manner in which the situation calls for, but in my role as a mediator, effective listening is listening to what the folks are saying about the problem and outlining the case, usually in civil litigation, but it's also listening to what the motivators are for the people. Sometimes you'll have folks who their case is characterized as a simple car accident, but they're really dealing with a lot of other issues that have compounded, and my role is to sort of sift through those things.
So you identified sort of the information or the analytical side of the listening task, but also the motivational side, or we might even say the emotional side of the listening task. How do you as a mediator go about drawing out both of those aspects of listening?
Well, number one, I have to listen in a more of an analytical setting. You have to listen for the nuts and bolts of a case. There's, plaintiff, defendant, there are facts, there's the burden of proof and things of that nature. And you're helping the attorneys, not so much with the law in their case, but you're listening to their characterization of the case. And part of my role is to give them my thoughts and feedback on whether I think they have a strong case. I'm not deciding the case like a judge or an arbitrator, but I am giving them sort of what I call the devil's advocate role and talking with them and saying, for example, Jen, I don't know if that's the best liability argument in the world that you're making. That's one aspect of it. The other, though, goes to the motivations. With Miles Mediations, my boss, John Miles, wrote a book, A New Day in Court. And what we talk about in that book is the different motivations in mediation. As is sort of the theme of his book, he initially thought it was all related to money. And sometimes it is a motivating factor. People want to get money. But the reality is there are a myriad number of motivations that can be affecting their ability to mediate that day. Sometimes they are being pushed by a pushy spouse. Sometimes they are comparing their garden variety automobile accident to a wrongful death case, and they're wondering why they're not getting millions of dollars for a case that might be worth $50,000. Other times you're reading people and really their reluctance or their hesitancy to go to trial, even though they're posturing like they will go to trial regardless of what happens at mediation. And you just have to listen with a nuanced ear to both sides. And sometimes they're overlapped, sometimes they're clearly separated, and sometimes the emotional part's not there. Sometimes with a more sophisticated plaintiff at times, or a relatively small and non-painful accident or case, it can just be sort of the nuts and bolts, like a very simple legal matter.
Right. You mentioned a nuanced ear. That is a great phrase, and I'm wondering how you would recommend lawyers to work on developing their nuanced ear as listeners.
A nuanced ear is probably a skill developed over time. It helps if you're nosy and inquisitive. We've talked before in the past on social matters, but a lot of times I'm very inquisitive about people. I'm interested in them and I want to find out. A long time ago, a friend told me the best way to assure that you have a good time on a first date is to ask the person a lot about themselves and get them talking. Well, that kind of skill, or that kind of skill translates as you become a lawyer. You're used to taking depositions and really parsing a matter out to find out the information. You don't lose that as a mediator. You still do that sort of same thing. But there is an emotional or an EQ sort of thing, an emotional quotient that you need to look at and really read body language, read the way people interact with each other, the way they interact with their attorneys. All those things come at you, and you can't be blind to them. So the nuanced ear, working in conjunction with what you see, you're using all your senses,
right.
Not smell so much, but you are trying to look behind what they're saying and beyond what they're saying, because a lot of mediations come in with a certain script and format. I go first if I'm the plaintiff's attorney. Here's the case. Boom, boom, boom. Here's what we hope to get today. Boom, boom, boom. Well, you have to watch and see if the plaintiff themselves if that person is with the attorney on what is being sort of laid out and prescribed as the landscape. And And that nuanced ear, I guess, is a phrase I just made up, but it is something that you have to have to be effective at the job.
What kind of nonverbals do you look for in sort of assessing the whole situation? As part of listening, is
Sure.
listening to the nonverbals as well?
It's the same that you might see with a child or someone in a social setting. Crossed arms, folded arms, furrowed brows, stoic expressions. You know me personally, but I bring a certain amount of levity to the situation. I understand, and I'm very respectful about the process. I know it's always very serious, very important to those people that day, and I try and give them their day in court. One of the things that helps me, Jennifer, in particular, as a mediator, I've been a claims adjuster, I've been a defense attorney, I've been a plaintiff's attorney. So in my opening, immediately I lay all those things out there, and I still garner respect from all the professionals in the room. After I've done that, the plaintiff or the layperson who's there as a non-professional, they usually buy into that authority because I let them know I've been in every chair here, I understand the process, and I explain the process. I use transparency, and as you explain things to people, you see their I don't know if it's a shell or their protective mechanisms sort of relax. Shoulders get relaxed, hands come unclenched, faces smile or show some expression. And then you read the expression, there are times where people aren't necessarily buying into what I'm saying, and I have to take it down a level. I don't speak in a condescending way, but you and I might talk at a level that people who haven't gone to law school wouldn't talk, at a level they wouldn't talk like, as I make up a word there, or a phrase, but I tailor my conversations to the people, and then I gauge their receptivity and their responsiveness to me. If they're still a stone wall, I try harder. If they're getting it and they're following along, I can kind of ease back a little bit.
So that is very helpful in terms of mediators being effective as listeners and sort of taking in the whole picture. I'm wondering what you see with respect to lawyers. Do you see lawyers being more or less effective, sort of dependent on their listening skills?
The good lawyers come in very well prepared. They've prepared their clients for both the process of mediation and litigation throughout. You can see that. They've talked to their clients from the first day they signed them up or the first day they were assigned the case, and everyone is on the same page. Typically with the defense side, they have another professional in the claims adjuster, so the adjuster knows as much, if not more, than the attorney, so there's not a lot of communication that's necessary for purposes of explaining, we've got to go to a mediation, here's what mediation is. But when I see the plaintiff's attorneys, if they are attentive and their clients look to them with either a knowing trust or a knowing comfort, I can sense that they're well prepared. But again, sometimes you put it in a doctor's contest, you hear that some doctors don't have a good bedside manner. There are some attorneys who have poor bedside manner. They don't pay attention to their clients. They seem to treat their clients as more of a nuisance or an annoyance. They don't seem to be advocating what their clients are seeking. There are a lot of times I have to pull the attorney out of the room and say, listen, I understand how you are posturing this case. I understand what you're saying. But in case you can't tell, your client does not want to go to trial. Do you see how petrified he or she is every time you mention trial and jury? We need to do what's best for your client. And sometimes there are differing motivating factors there because the attorney wants to get as much money as possible, and the only way to do that sometimes from a plaintiff's perspective is to make the defense feel like you're going to trial. The defendants sometimes just want to get out of there. And I don't know if I'm putting too much legalese or mediation talk into it, but if the good listeners, as far as attorneys, they come across as more genuine on top of their clients' cases. I never see instances of looks of like, what does that mean? Looking around scared or shocked. They seem to be in tune and their clients seem more prepared for the process. As a mediator, what I try and do for those folks who aren't well prepared, don't seem to be good listeners, is I go out of my way to explain more and make the process that much more transparent and buy in and try and get the plaintiff or the client, the layperson, comfortable with what we're doing. And there are times where, like I said, I'll have to pull the attorney out and just say, come on, what are we doing here? And they understand when I do that I'm not trying to embarrass them. I'll never do that in front of their client. I'll never make them look bad. I'll never throw them under the bus. But I will make sure that if they weren't listening to their client, they'll listen to me, and I'll just talk to them very directly.
So if a lawyer wants to improve at his or her listening independently without being told by a mediator, you need to listen better, what could a lawyer do to enhance those skills?
Take a little time and focus on what you're doing. Attorneys are renowned for their ability to do multiple things at once. They can be thinking about other cases during a case, and a lot of times attorneys with a lot of files, they don't have a chance to prepare for a mediation or any sort of legal activity much more than maybe the night before or a week before if it's a really big case. I would ask or suggest that they take a little bit of extra time to just prepare and know the case, know their clients, and just review things. Attorneys have an amazing ability to retain a lot of knowledge in a short amount of time for at least a little while. And they need to do that more, I think, to be on par and be up to speed with their clients. But other times it's just asking questions. I don't know how you can coach empathy. I don't know how you can coach sort of emotional evaluations of people. The older I've gotten, I thought everyone could do that. I don't know that everyone can. Quite frankly, I don't say that to toot my own horn. I just see that some people do not have those skills, and that's fine. But you can work on it if you don't. You can take a course, read a book, talk to a spouse, talk to your own kids, and try and read body language and see where things are going, and that can help you. But at a minimum, an attorney, even if they can't do any of those things, they can fake it by just asking the questions. Even if they're robotic and methodical in the way they do it, they can ask the questions and get there.
Greg, thank you so much for being here and sharing your thoughts on listening skills. I really appreciate your time.
Thank you.